Chairman Wright, give him a second. There's Chairman Farmer. All right, House Education Subcommittee is now in session, and members, if you will go ahead and log in, and we'll take roll in just about a half a minute here. I don't think he's in. Chairman White. All right, Mr. Clerk, if you would open the board for roll call. All right, there we go. Mr. Clerk, please take the roll.
Mr. Chairman, you have 6 members present. You have a quorum.
All right, thank you very much. And members, any personal orders before we get started? All right, we'll get right into it then. This is our final calendar, members, as you know, and I think we should be able to dispense with the calendar today. Let me go over a couple of bills that have been requested to take off notice. Item number 3, House Bill 1117 by Chair Lady Carringer is off notice without objection. Item number 4, House Bill 2488 by Chairman Haston, off notice without objection. Item number 11, House Bill 1032 by Representative Dixie is off notice without objection. Also, item number 12, House Bill 953 by Representative Brooks is off notice without objection. And then item number 1 on your addendum calendar, House Bill 1998 by Representative Stevens is off notice without objection. So I think that is all the updates to our calendar. With that, that brings us to our final calendar, regular calendar. Item number 1, House Bill 656 by Chairman Farmer. You are recognized. Properly motioned, properly seconded, and I do see that you have an amendment. Is that correct?
Yes, Mr. Chairman. It looks like that should be 014563.
That is correct. We have a motion. Do I have a second? Seconded. So members, let's go ahead and put that on the bill for proper explanation without objection. All those in favor say aye. Aye. Any opposed? 014563 is now on your bill.
Very good. All right. Thank you, Mr. Chair. Members, this amendment clarifies legislation that we passed last year that allowed payment of unused sick leave to the families of deceased teachers. And what I should have done then was just let it apply to any school LEA employee at that point in time. So this is what this is doing. This is to open it up. It's a permissive bill. So if an LEA has a janitor, a cook, or whomever was to pass away and have sick leave or some annual leave left, that school district or LEA can then, if they want to, they may pay the designee or beneficiary or the estate of that deceased employee. So it just opens it up to kind of provide for everyone, treat everybody the same.
Thank you for that explanation. Any questions from our members? Seeing none, we're ready to vote on House Bill 656. Mr. Clerk, if you'd open the board for voting. Members, please cast your vote. Does any member wish to change their vote? Mr. Clerk, please take the vote.
Mr. Chairman, you have 5 ayes, no nays.
House Bill 656 moves on to full education.
Thank you, Mr. Chair, committee.
All right, that brings us to item number 2, House Bill 2275 by Chair Lady Moody. Motioned and seconded. Now, here's a question even before you get to your bill.
I'm ready.
Is this your last bill in this committee? This is the last calendar, so that's a clue. So-
Well, I was trying to think how I could make something up.
Oh, well, there you go. Well, we're not planning on putting together another calendar, but thank you, Chair Lady
No, we're
Moody.
good.
And you've been a part of Education Committee in the past, and many of us have served with you in education, and we're surely going to miss you in that. Chairman Sapicki, you're recognized.
Thank you, Mr. Chairman. Yes, I came here 8 years ago and sat with Chairman Moody on education, and we fought many battles together.
Yeah.
And became one of my most dearest friends up here. And I'm going to miss you so much, that you mean so much to me. And so you have helped us move education to where it's never been in the state of Tennessee. And I hope as you leave us, you remember how important you were to us getting there. And a dear friend I'm going to miss. So I'll be happy to be able to vote one more time yes for your bill.
Okay. Thank you. Well,
Go ahead, Chair Lady Moody. Any comment?
does anybody have Kleenex?
Chairman White, you're recognized.
Thank you. I remember,
Okay.
of course, this is my 17th year, and I remember driving from Memphis up here on 40 one day, and we were talking on the phone. You said you're going to run, and we were talking all about the pros and cons and the goods and the bads, of running. And I can't believe it's been that many years already. But this is not her last bill because she's changing her mind. She's going to run again. Appreciate you so much. Appreciate.
Oh, thank you. Well, it's been a blessing to be here and get to know each one of you and the staff. It's just so I'll have my speech ready later because I don't know. I can finish. But thank you for your kind words.
Well, we will see you in full. So we'll see if we have time there in full, but we've
There
got
you
time
go.
in sub today. So thank you, Chair Lady Moody, for everything
Thank you.
that you've done for education in Tennessee.
Thank
So,
you.
all right, that does bring us to House Bill 2275 by Chair Lady Moody. Do I have a motion? Motion and a second, and I see there are a few amendments that are listed here. Which amendment or amendments are you running with?
Yes, Mr. Chairman. Today we're using 014909.
All right, motion and second. Members, let's go ahead and put that on the bill. All those in favor of putting that amendment on the bill, say aye. All those opposed? Your bill is properly amended and before us. Chair Lady Moody, you're recognized.
Thank you so much. Members, what we have come up with greater minds than mine, and two of those minds are here in the audience, Brink Fiddler and Adam. I can't remember your last name, but they were very instrumental and have the expertise in this school safety realm. So what this amendment will do, it will create a safe school design advisory board to recommend to the Commissioner of Safety safe school design guidelines for our LEAs and public charter schools to consider when constructing or remodeling kindergarten through grade 12 public school facilities. It is attached to the Department of Safety, and the commissioner will be able to call the first meeting, and it tells the different areas that we would like the people that will hold those positions of the boards to be from. And basically what we're just trying to do, we're focusing again on safety. So any designs that could, of course, pertain to active shooters, those kind of issues that we unfortunately have to deal with. But this would be their purpose, and recommend those things that, excuse me, as technology changes and all, it's amazing what we could do, and to protect our children and the teachers and the other adults in those schools. So this is establishing that board to do that work for us.
Thank you, Chair Lady Moody. And, I was speaking with a group of firefighters last week, and we were talking about how fire safe our schools are. We can always do more, but how fire safe our schools are. But that comes from decades of of work when it comes to fire safety. And it's unfortunate, but true. We need to be concerned about school security as well. And so I think as we continue to move forward, especially as we build new buildings, that it will be very important to have folks in place that are guiding those, working together with architects so that we can implement those safety features that I think any school building will have in the future or should have in the future. So this is an excellent bill and an excellent explanation. Any members have any questions for our sponsor? Seeing none, we're ready to vote on House Bill 2275. Mr. Clerk, if you please open the board for voting. Mr. Clerk, please take the vote.
Mr. Chairman, you have 6 ayes, no nays.
House Bill 2275 moves on to full education.
Thank you, Mr. Chairman and committee. Love y'all.
All right, members, that brings us to item number 5, House Bill 2423 by Representative Martin. Properly motioned, properly seconded. I don't see any amendments on this bill, so we're ready to hear you on your bill.
Thank you, Chairman. House Bill 2423 helps schools recruit new librarians. One of the principals from a high school in my community, and the principal is in my district, asked if we could expand the pathways for her to hire librarians. Currently, an applicant must be a certified library information specialist to be eligible for employment. This bill expands eligibility in 2 ways. First, it qualifies an advanced degree in media and technology to lead to a library information specialist endorsement. Applicable degrees would be determined by the State Board of Education and the Department of Education. And second, it provides the option for schools with less than 750 enrolled students to employ someone with a valid teaching license as a school librarian. This language scheme is from the State Board of Education's rules for K through 8. And with that, Mr. Chairman, I stand ready for questions from you.
Thank you
and/or
for
the
that
committee.
explanation. Members, any questions for our sponsor? Seeing none, we are ready to vote on House Bill 2423. Mr. Clerk, please open the board for voting. Members, please cast your vote. Mr. Clerk, please take the vote.
Mr. Chairman, you have 6 ayes, no nays.
House Bill 2423 moves on to full education.
Thank you.
That brings us to item number 6, House Bill 2327 by the other Representative Martin. I have a motion, second, I'll second it. And you know, I should have said Representative Martin from Hamilton.
That's right.
But I've forgotten your county, Representative Martin. Help us-
Carol will work.
Carol.
Yes, sir.
All right, there we go. And I should have known that
Hey, I appreciate it.
based on our time in Gettysburg and
That's right.
the chatting that we got to do.
That's
So
right.
very good. So let's see. I do see that you have an amendment. Is that correct?
That is correct. 014086.
That's what we have. Have a motion. Do I have a second? Seconded. Members, let's go ahead and put that 01406 on the bill. All those in favor say aye. Any opposed? Your bill is properly amended and we're ready to hear you on.
Thank you, Chairman and committee. I do want to take a quick personal order, if you don't mind. I have some constituents here from Henderson County Leadership. I'm a graduate of that just 2 years ago, so they're here watching as well today. So take it easy on my bill in front of them, please.
Very good.
House Bill 2327 is about parent choice, ensuring students with autism spectrum disorder receive the services they so desperately need. More specifically, this bill requires our LEAs and public charter schools to allow licensed private pay providers of applied behavioral analysis services, or ABA services, access to students during the school day on school grounds. This is happening currently in several counties across the state, and many more are wanting access to do that. This bill puts a solid framework and guardrails in place to ensure it's done properly in the best interest of the child. These guardrails are for schools, families, and providers so that the services are coordinated, appropriate, and non-disruptive. It requires coordination with the student's IEP team and execution of a memorandum of understanding between the private pay provider and the LEA or public charter school before the services begin. It's important to note that these private pay providers are an additional and in no way satisfactory to the requirement of a child's IEP. The bill is in no way reduces the LEA's responsibility to provide a child with FAPE as mandated by the IDEA. Bottom line, this bill is about parent choice, student access, and collaboration. It protects school systems while ensuring children who need additional support can receive it without unnecessary barriers. I see this as a win for our students, for our parents, and for our teachers, and I humbly ask for a favorable vote.
All right, thank you, Representative. Chairman White, you're recognized.
Thank you, Chairman. Speaking of Carroll County, Huntington, what's the favorite restaurant we ate at?
Mallards, anytime.
Mallards.
Yes,
If you're ever in Huntington, Mallards, eat there for a restaurant. It's a great place. I just had one note on to ask you, clarify for me. I said, districts can already do this. Help me out there.
There are, no, excuse me.
You're recognized.
That's right.
Go ahead.
There are some across the state that already have private pay providers in service. I believe Chairman might have a district that has that access. We don't have it across the state though, so this would make it uniform across the state.
Thank you.
Yes, and that is correct. This is somewhat of a patchwork. This is a positive for the student, certainly first, also for parents and for the school as well. And so I think this good legislation before us. Thank you for bringing it.
Yes, sir.
All right.
Thank you.
Any other comments or questions for our sponsor? Seeing none, we are ready to vote on House Bill 2327. Mr. Clerk, please open the board for voting. Members, cast your votes. Any member wish to change their vote? Mr. Clerk, please take the vote.
Mr. Chairman, you have 5 ayes, 0 noes, and 1 present not voting.
House Bill 2327 moves on to full education.
Thank you, Chairman and committee.
All right, that brings us up to item number 7, House Bill 2329 by Representative Davis. Do I have a motion? I have a motion and a second. Representative Davis, I do see that you have an amendment. Is that correct?
Yes, Mr. Chairman, I do. And the amendment makes the bill. So it's 014049.
Seconded, and let's go ahead, members, and add that amendment so we can discuss the bill. All those in favor say aye. Any opposed? You're ready to be heard on your bill as amended.
Thank you, Mr. Chairman. Thank you, committee. So this legislation, what this does is it establishes a program. It creates a statewide school nurse grant program, and it's administered by the Department of Education. It helps school districts and public charter schools hire and retain full-time licensed school nurses. School nurses play a critical role in keeping students healthy, responding to emergencies, and managing chronic conditions. It also helps students stay in school and be ready to learn. These grants, the funding is separate from TISA funds, so it's very similar to how we established the SRO grant program. It's very similar to that program, and the funding would be subject to annual appropriations, given the General Assembly the flexibility. Grants would be awarded per nurse position, not per student, and can only be used to cover the salary and benefits of full-time licensed nurses serving the general student population. The grant amounts are capped at an average cost of employing a licensed practical nurse, an LPN, as determined by the Department of Education in consultation with the Department of Health. While the grant amount would be capped at the value of an LPN, those funds may still be used towards a registered nurse's salary and benefits. Priority would be given to the districts that have the greatest need, such as those with high enrollment and significant student health needs or limited access to nursing services. This bill does not mandate any staffing levels, but it gives districts a practical tool to move closer to the standard with state support. The local districts retain flexibility and can supplement any grant funds with any other resources that they choose. And so with that explanation, I stand ready for any questions.
All right, thank you, sponsor. Any questions from our members? Seeing none, we are ready to vote on House Bill 2329. Mr. Clerk, if you'd open the board for voting. Members, please cast your vote. All right, Mr. Clerk, if you'll take the vote.
Mr. Chairman, you have 4 ayes, no nays.
House Bill 2329 moves on to full education.
Thank you, Mr. Chairman. Thank you, committee.
All right, that brings us to item number 8, House Bill 2149 by Representative Jones. To have a motion, seconded, and I don't see, I do see an amendment. What's your drafting code there?
014594.
All right. Motion on the amendment, seconded, and let's go ahead, members, put that on the bill so we can discuss it. All those in favor say aye. Aye. Any opposed? The amendment is added onto the bill. We're ready to hear you on your bill.
Thank you. The amendment makes the bill. What we're seeing in a lot of our schools is that due to either disciplinary issues or truancy issues, students are withdrawing and then coming back a few months later and re-enrolling just to escape some of the issues of discipline consequences. So what this bill would do is that it says an LEA or public charter school may continue a disciplinary investigation of a student who during the investigation withdraws from the LEA or public charter school. If a student withdraws from an LEA or public charter school during a disciplinary investigation of the student, and the student later re-enrolls in the LEA or public charter school, then the LEA or public charter school may discipline the student in accordance with the LEA or public charter school's policy based on the results of the disciplinary investigation of the student. So it's just kind of trying to put the consequences to where they can't, when they re-enroll, because Chairman White, we've heard our directors talk about that this is a real issue in our schools.
All right, thank you for that explanation. Chairman White, you're recognized.
Thank you, Chairman Slater. Yeah, and thank you. How many iterations are we trying to get there? You would think something simple, but it's never simple. But back in November, we had a meeting with a lot of the upper East Tennessee districts, and it's a real problem. And I'm all for school choice, but you got to have accountability. And when we have students being removed from the public school or the charter school because of discipline issues, but so you've worked hard to get the language right. So I fully support this, and I hope this has an effect and addresses some of the need that our school districts, especially up in Northeast Tennessee, brought to us.
Yes, sir. Thank you.
Now, I would mention that, members, you may remember that Chairman Raper had a bill that seemed very similar. His was different in the fact that his dealt with truancy. And so if there was a truancy issue, a student withdrew and then came back, then that issue would still be before. There would still be the consequences of truancy there. This is in a different area, so similar in nature, but different topics. Members, any other questions for our sponsor? Seeing none, we're ready to vote on House Bill 2149. Mr. Clerk, please open the board. Members, please cast your vote. All right. Does any member wish to change their vote? Mr. Clerk, please announce the vote.
Mr. Chairman, you have 6 ayes, no nays.
House Bill 2149 moves on to full education.
Thank you, Chairman and committee.
All right. That brings us to item number 9, House Bill 1785 by Representative Reeves. I have a motion and a second. And Representative Reeves, I see an amendment. Is that correct?
We do have an amendment, Mr. Chair, 13378.
Motion second. Members, let's go ahead and put that on. All those in favor of the amendment say aye. Aye. Any opposed? All right. Well, the ayes have it. So the bill is before us as amended. All right. Representative Reeves, you're recognized.
Thank you, Mr. Chair. This bill emerges from the desire to provide athletic opportunities for high school students that attend small private schools of less than 200 students with this amendment that may not offer certain sports. And it allows those students to participate in sports at the public high school that they are zoned to attend, and only in sports that are not offered by that student's particular school. And it essentially treats students at small, very small private schools the same as how homeschool and virtual school students are now treated relative to their participation in athletics.
All right, thank you for that explanation. Chairman Sapicki, you're recognized.
Just for clarification on the amendment, we have an explanation from legal that says it deletes the requirement that the private school be located within the geographic bounds of the LEA. Is that what the amendment did?
Now, the amendment that I added just said that is enrolled in a private school that serves fewer than 200 students.
All right, let's go ahead and go to legal and make sure that we're clear on the amendment. Members, we're out of session. You're recognized.
Thank you, Mr. Chair. Katie Robertson, Office of Legal Services. The bill in Section 1, Subdivision A1A is the requirement is enrolled in a private school that serves fewer than 200 students and is located within the geographic boundaries of the LEA. The amendment that was just adopted deletes within the boundaries of the LEA. So the private school requirement would be that the serves fewer than 200 students.
So you don't have to.
Question for legal?
So just for clarification, if the private school student can go outside the LEA to go to school and play sports, is that correct?
You're recognized, legal.
The student would be required to reside within the geographic boundaries of the LEA. The amendment is only referencing the location of the private school. So in the bill, subdivision A1C requires that the student reside within the geographic boundaries of the LEA.
You good, or?
Just to clarify, that if a student is going to take advantage of this bill, that they are restricted to the geographic LEA boundaries, and they have to go to the school that they're zoned for.
Yeah, legal, you're recognized.
That is correct.
Thank you very much.
All right. Any other questions for legal while we're out of session? Seeing none, members, we're back into session and back to the sponsor and members' questions. Representative Glenn, you're recognized.
Thank you, Mr. Chairman. Quick question. If a student decides to play football, a private, however this bill is put together, who ensures that private student that came to play football? Because all schools have to have some sort of insurance as it relates to sports. But if that student is not enrolled in that school, who insures that child?
Sponsor, you're recognized.
It would be the same answer as a homeschool or virtual school student who is similarly situated. And I don't have the specific answer for you, but I know that it puts them on par with those circumstances.
Representative Glenn, you're recognized.
Thank you, Mr. Chairman. And I think that's the problem I have with the bill is if a student is not enrolled, but yet they want to play sports with that school becomes liable for that child, even though they're not receiving any of the funded dollars that go with that child. And so I think that's probably why I got a problem with that legislation, but I got you. Thank you so much.
Representative Reeves, you're recognized.
And I'll just say in response that school actually is getting dollars associated with that child who lives in that LEA and is contributing through property tax and other things. Thank you.
Chairman White, you're recognized.
Thank you. And thank you, Chairman Slater. I just want to get clarity. I want to make sure I have notes here and might have to go to Chairman Spicky. What we went through last year with the one-time transfer and the TWSAA. I want to make sure we're not affecting anything that we did in that legislation last year. Can you address that or recognize?
You're recognized, Representative Reeves.
Yeah, thank you. What I know about it is it does not supplant the authority of TSSAA. Chairman Spicky, I respect that you say that fluidly all the time to determine any eligibility requirements or anything like that.
All right. Any other questions? Chairman Spicky, you're recognized.
And then and it says fewer than 200, is that total enrollment of the school K through 12?
Sponsor, you're recognized.
Yeah, 200 students at that school. Yeah.
Chairman Sapicki.
And if the school would happen to offer the sport that the student wants to play, would they be prohibited from going to a public school and playing the same sport?
You recognize?
Correct.
Chairman Sapicki.
Unless they invoke the one-time transfer we just passed.
Representative.
It doesn't supplant anything that you have put together.
All right, any other questions? And Representative Glenn, to your previous question, and I don't want to get in too deep because I may be in over my head pretty quickly, but as it relates to liability, for example, there are liability policies or insurance policies that cover students who are playing, even though they may be coming from another school. If that was part of your question, I believe that that's the answer in those blanket type policies. So, okay. All right. Any other questions for our sponsor? All right. Seeing none, we are ready to vote on House Bill 1785. Mr. Clerk, please open the board for voting. Members, please cast your votes. Anyone wish to change their vote? All right, Mr. Clerk, if you would please report the vote.
Mr. Chairman, you have 5 ayes, no nays, and 1 present not voting.
All right, House Bill 1785 moves on to full education. That brings us to item number 10, House Bill 2076, also by Representative Reeves. So I have a motion and a second. And Representative Reeves, I see you have which amendment or both?
We've gone through some iterations, Mr. Chair. I've got 14871.
Okay, so, all right. So 1014871, properly motioned, properly seconded. Members, all those in favor of adding the amendment, say aye. Aye. Any opposed? The amendment is added to your bill. You're ready to be heard on your bill as amended.
Thank you, Mr. Chairman. This amendment replaces the bill with a TASSER study focused on ultra-processed foods in school nutrition programs. And under the amendment, TASSER, the Tennessee Advisory Commission on Intergovernmental Relations, will evaluate the prevalence of ultra-processed foods, or artificial dyes and other chemical additives in food and beverages served through the school nutrition program. With that, I'm available for questions.
All right, members, you've heard the explanation. Any questions for our sponsor? Seeing none, we are ready to vote on House Bill 2076. Mr. Clerk, please open the board for voting. Members, please cast your vote. Does anyone wish to change their vote? Mr. Clerk, please take the vote.
Mr. Chairman, you have 5 ayes, no nays.
House Bill 2076 moves on to full education.
Thank you, Chair and Committee.
All right, that brings us to item number 13, House Bill 1974 by Chairman White. Do I have a motion? I have a motion and a second. And Chairman White, I see you have an amendment. Which amendment?
I believe we're operating off 14856.
All right, amendment 014856, properly motioned, properly seconded. Members, all those in favor of adding that amendment, say aye. Aye. Any opposed? The amendment is added to the bill, and we're ready to hear you on your bill.
Thank you. Members, this bill, I call it the Student Order of Protection Bill. It's one of those bills I've gone through many iterations trying to get the language right, kind of like Representative Jones and her bill as far as accountability for students being in school. But I got this from I was talking to a parent up in Knoxville, and she had a daughter that was in the public school, and she had been sexually molested by another student. It wasn't a rape or anything, but it was so she got an order of protection from this student. But when they went back to school, the school administration, according to what was relayed to me, they wouldn't do anything about it. The young man was still in the same classes with her, and there was like a big, I think like a music class at the end of the day, and he was in there. He was still laughing, and she just felt very intimidated. And the mother had a court order of protection. So what this bill is simply laying out says if a student has a court order of protection to protect the student who who is enrolled in the same school, then a school safety plan must be developed within 5 school days from the time the school receives the order of protection. The safety plan must be developed by the school principal, a school safety team if applicable, with input from the parent or guardian of the student that has the order of protection. And then a plan for the physical separation of the students with order of protection removal of the respondent, which is the perpetrator, from shared classes and school-sponsored events. In other words, just, you can't take the child out of the school, but just don't keep them in the same classrooms throughout the day or anything where the perpetrator is in there with the student that has the order of protection. And it's up to one last thing. I see. It says the parent or legal guardian of the student who is named as the petitioner in the order of protection shall notify the school within 48 hours of any changes to the order of protection to allow the school principal and school safety team to revise the student safety plan. So they're required to put a safety plan in place just to protect the student who has an order of protection.
All right. Thank you, Chairman White, for that explanation. Any questions for our sponsor? Seeing none, we are ready to vote on House Bill 1974. Mr. Clerk, please open the board for voting. Members, please cast your vote. Any member wish to change their vote? Mr. Clerk, please take the vote.
Mr. Chairman, you have 5 ayes, no nays.
House Bill 1974 moves on to full education. That brings us to item number 14, House Bill 2257 by Chairman White. Do I have a motion? Have a motion and a second. Chairman White, do I see an amendment on this bill?
Let's look at 14215.
That's what I have here. Properly motion, properly seconded, 014215. Members, let's go ahead and put that on the bill. All those in favor say aye. Aye. Any opposed? No. All right. Your bill is properly before us as amended, Chairman White.
Thank you. And members, what this is, dyslexia bill, it's been brought to my attention many times. I have many conversations throughout the year, and I was talking to a parent of an 8-year-old the other day. Too many of our students are slipping through the cracks that have dyslexia. And even though we say in some systems we try to address this, we're letting far too many students slip through. If you catch this early, it is preventable or as they go through school. But in trying to put something together, I've come up with what we can come up. What this does is requires the State Board of Education to establish a qualified dyslexia interventionist endorsement to allow educators to provide targeted instruction intervention, academic support, behavior support, and related services to the students demonstrating the dyslexia. It also requires an educator to hold a certified structured literacy dyslexia interventionist credential issued by the Center for Effective Reading Instruction in partnership with the International Dyslexia Association and satisfy any additional requirements established by the State Board of Education to receive the endorsement. And lastly, clarifies that educators who do not hold the endorsement are not prohibited from providing services to students demonstrating characters of dyslexia if they are otherwise authorized to do so. So what I'm just trying to do, bring attention, we need and we don't have enough of these kind of people, but had a parent back in Memphis the other day. Their child is 8 years old and they've just almost lost this child because they weren't diagnosed. They was in a school where they didn't have the services available. And now this 8-year-old child is really years behind in education already because of that. So I just think we're trying to create a system where we're paying more attention into the proper way to treat dyslexia in the early grades of the school year. And that's basically what this is trying to do. So with that, I renew the motion.
All right. Thank you, Mr. Chairman. Any questions for our sponsor? Seeing none, we are ready to vote on House Bill 2257 as amended. Mr. Clerk, please open the board for voting. Members, please cast your votes. Does any member wish to change their vote? All right, Mr. Clerk, please go ahead and take the vote.
Mr. Chairman, you have 5 ayes, no nays.
House Bill 2257 moves on to full education. All right, members, that brings us to item number 15, House Bill 2096 by Chairman White. Motion. Properly motion, properly seconded. And I see here, what amendment are you?
15272.
Okay.
Is that, yeah, that's great.
Okay, so that motion or that amendment is untimely filed. So we typically do not take up untimely filed amendments. However, as you know, this is our final calendar.
Motion for consideration.
All right. Motion and second for consideration. Members, that's what we're voting on, considering whether to take up this amendment. So all those in favor say aye.
Aye.
Any opposed? All right, so we will consider Amendment 015272. Do I have a motion on the amendment?
Let's hear from about the amendment.
Okay, there we go.
Okay, I believe, doesn't the amendment make the bill?
Yes, it does.
It does, okay. So let me explain what it does. This is also brought to me, I don't know if the parties that brought this to me are in the room or not, but what they're asking for on this particular one is that there have been situations, a school board meeting may be conducted with electronic participation as long as you have a quorum of members present at the location of the meeting if you have inclement weather or a natural disaster that makes physical presence of the quorum of members impractical or unsafe. Provided that a board meeting must not be conducted with electronic participation without a quorum, and each of the members have to be identified that who is on the board meeting, and they can't do this any more than 3 times a year. But it's from what I understand, being brought to us is that if you cannot meet, such as the disasters we had in Cobb County and others in West Tennessee, if they can't get there, they can join by electronic participation, but there must be a quorum present and they must be identifiable. I think I've explained that correctly.
Okay, so.
Motion to accept the amendment.
Okay, so motion to accept and seconded. All right, members, we are voting on whether to accept Amendment 015272. All those in favor say aye. Aye. Are there any opposed? The ayes have it, and so that amendment is now on the bill. And question has been called on the bill. Any objection to the question? Seeing none, Mr. Clerk, please open the board for voting. Members, please cast your vote. Any member wish to change their vote? Mr. Clerk, please take the vote.
Mr. Chairman, you have 5 ayes, no nays.
House Bill 2096 is amended, moves on to full education. All right, members, that concludes that calendar. We do have an addendum. It is marked March 10th addendum. And item number 1, you'll remember, was taken off notice. That brings us to item number 2, House Bill 2410 by Chairman Raper. Properly motioned, properly seconded. I don't see any amendments. Is that correct, Chairman?
It's a clean bill.
All right, so you are ready to be heard on your bill.
Thank you, Mr. Chair, and thank you, committee. House Bill 2410, which gives local school districts the option to install video cameras systems in special ed classrooms for the purpose of protecting both students and teachers. This bill is entirely permissive. It does not mandate cameras. It simply allows an LEA or public charter school to install a continuous monitoring system if and only if the parents of the majority of students in that classroom consent to it. And obviously, if you have 21, then 11 would have to vote in favor. Next thing is, this bill also includes strong privacy protections. Any photographs or video footage collected under this section may be only viewed in very limited circumstances. A parent may view footage only if their child is featured, and a teacher may view footage only if they believe it contains evidence of an assault against them. And even then, all access must comply with Tennessee Code Annotated and I'll say it out so if anybody doesn't know, Family Educational Rights and Privacy Act, which is FERPA. These two laws work together to ensure any footage containing identifiable student information is treated as a protected education record. This means that it cannot be publicly released and it cannot be shared for what FERPA allows. House Bill 2410 does not weaken or alter those protections in any way. It simply ensures that that when safety concerns arise, the appropriate parent or teacher can view the relevant portion of the recording while still honoring all state and federal privacy requirements. The bill also requires each participating district to adopt a local policy governing how long footage must be retained. So once again, just to paraphrase, that is a local decision as far as how long. And finally, expresses the General Assembly's intent that installation costs must be supported through available school safety grants. In short, House Bill 2410 balances two important priorities: protecting vulnerable students and teachers and safeguarding student privacy under both state and federal law. I renew my motion.
All right, thank you, sponsor. Any questions for our sponsor? I have a question, and you had mentioned that under certain circumstances that a parent could view the videotape. Could you go back to that and address that again? Under what circumstances may a parent view a videotape?
Thank you for the question. Very good. Yes, this is only when their child is involved in something that could be subject to maybe an abuse case, anything like that. But they're the only ones that can view that footage, and they have to do it upon request of the principal. But only in those cases. If their child's anywhere else in the room and it's not on footage, no, they can't do anything like that. Or say another parent in a room just wanted to view something, but no problem at all. There are no problems that we know of. They can't do it. So it's only when a child it has reported a problem, or in some cases they cannot. They're nonverbal and so on. But somehow a parent suspects something, then they may ask the principal at that point, please allow me to do so. So those are the only ones. The rest of the room in the self-contained classroom cannot request that.
And I think you mentioned this, but I want to make sure that I'm clear on it. This is permissive in nature in that the LEA can determine whether or not there would be a recording device. And then with that permissiveness, also they would bear the cost. Is that correct?
Yes. By the way, if you recognize me, yes, that is absolutely correct. And two things. First of all is, yes, the whole thing is permissive. And here's 2 or 3 situations about that. First of all, if you have a person, right now we have a couple of LEAs that I know of participating. Okay. So they would automatically want to roll over and continue to do this. Actually, I've talked to both systems. Okay. The next thing is you may have others want to come aboard, and I've been, there are different LEAs that reached out to me saying they would like to do this. Okay. But anyone else can decide they want to, decide they do not want to, and that's year by year. You know, if this was passed and we went 2 or 3 years and people are liking it, they can join in then. And then going back to the funding, this is off of any available safety grants, educationally or non-educationally, school related or not, anything that they would comply with, then that's where the money comes from.
So your intent then, it sounds like, I don't want to put words in your mouth. It sounds like your intent is safety, not recording of behavioral issues unless there was a safety issue.
That's absolutely correct.
Okay, thank you. Members, any other questions? Representative Glenn?
Thank you, Mr. Chairman. Sponsor, I just got one question. You mentioned that the majority of the parents have to agree. So if there is a parent that is adamant, they do not want their child recorded, what is the remedy for that? Because that, there's a privacy issue there. So what is the remedy for that parent that's just adamant that they don't want their child reported?
You're recognized.
Thank you for the question. Do I have a remedy? No, sir, I don't. But where that wording and that verbiage derived from is it's current state law right now that there has to be a majority to do something like that in a special ed classroom.
Any other questions? All right, looks like we're ready to vote on House Bill 2410. Mr. Clerk, if you'd open the board for voting. Members, if you'll cast your votes. Mr. Clerk, please take the vote.
Mr. Chairman, you have 4 ayes, no nays, and 1 present not voting.
All right, House Bill 2410 moves on to full education.
Thank you, Mr. Chair and committee.
All right, members, we have also a special calendar which is marked March the 10th. And we have a member that is on that calendar with House Bill 448. Before any comments on that, let me just mention that the companion bill in the Senate was gen subbed last year. That can be brought back up again. Of course, that would be up to the sponsor and up to the Senate to take that up. But it is currently gen subbed. I would entertain a motion to have House Bill 448 heard by Representative Glenn. I have a motion. And a motion and a second. Okay, Representative Glenn, do you have an amendment that you're working off of?
Yes, I do, Mr. Chairman.
All right, what's that drafting code?
It is 014280.
All right, all right, a motion and amendment on the, or a motion and second on the amendment. All those in favor of adding the amendment to the bill, say aye. Aye. Any opposed? The amendment goes on to the bill, and Representative Glenn, we're ready to hear you on your amended bill.
All right, thank you, Mr. Chairman. This bill was brought to me actually about a year or so ago, a little over, in reference to an issue that took place in Montgomery County that involved a nonverbal child where a teacher put her hands on a nonverbal child in a way that was not the way it should have been done. And the part of that is because so many of our teachers deal with special need kids throughout the day, whether they have the necessary training or not. When we integrated the schools, the classrooms, when we integrated the classroom, we integrated them with kids with special needs as well. So not all teachers receive the full training as it relates to special need kids. So what this bill essentially does is that it offers four trainings for all teachers, whether they are a special need teacher or not. And it gives them the tools to be able to handle those kids when the time is needed and until the actual qualified special need teacher arrive. And so the 4 additional classes that they would take during in-service, and it would be all teachers, would be response, interruption, and redirection, differential reinforcement and alternative, incompatible and other behavior training, behavior momentum intervention, and augmentative alternative communication. Those 4 additional classes will arm our teachers, all teachers, with the tools they needed to deal with a special need child, because the special need teachers get that training, but the teachers who are not special need teachers do not. So this just gives them the training they need to be effective and to ensure that they don't have a problem and cause them to lose their jobs and because of a moment lacks of what needs to be done. So that's what the bill does, Mr. Chairman.
All right, thank you for that explanation. Any questions from our members? Representative Reedy, you're recognized.
Yeah, thank you, Mr. Chairman. Representative Glenn, of course, the status of the bill in the Senate. When will we know if they're going to move that forward? Do you know?
You're recognized.
Yes, so the status would move once and if, and I hope the if is yes. If we move it from here, then the sponsor in the Senate can then request that they move it, bring it back up in the Senate and move it forward. But we have to move it here first.
Because my request to you is if we move it to full, and if they don't take it up in a timely fashion, that you just, take the bill off notice.
Correct.
Thank you, Mr. Chairman.
And they would, in the Senate, they would have to suspend the rules. They're on their final calendar, so there's somewhat of a lift there for them to do that. Any other questions for Chairman White? You're recognized.
Thank you, Chairman. Not really a question, just a thought. And I understand what you're getting at, and I'm in agreement. But since we're requiring the LEAs, is there any issue with the state DOE, or do we have the training sufficiently to get this done across the state for 2 hours each year? Have you talked about that? How the logistics work is what I'm concerned about.
So
you're recognized.
Thank you, thank you, Chairman White. Yes, I did ask and work this out with the Department of Education. They are in full support of it. There would not, it would be done during in-service. This training is already given to our teachers who are special need teachers. And so all this training is doing is taking those 4 pieces and ensuring that all teachers receive it. And again, it'll be done during in-service when they're receiving all their training anyway. So it just adds those 4 pieces to training that they're already getting doing in-service. It won't require them to have to do anything different as it relates to regular school hours or anything like that. It's all part of the in-service piece. And yes, I did talk with the Department of Education, and they're on board with it.
Thank you.
And let me, I think I'm correct in saying this, Representative Glenn. I think with the amendment, the 2-hour requirement, in other words, the 4 pieces stay in, but it's not mandated a certain number of hours. Right. So members, just so that we recognize that it's not a certain number of hours, it is those 4 topics, but there's not a mandate on required number of hours. Okay. Any other questions for our sponsor? Seeing none, we are ready to vote on House Bill 448. Mr. Clerk, please open the board for voting. Members, please cast your vote. Mr. Clerk, please take the vote.
Mr. Chairman, you have 6 ayes, no nays.
All right, House Bill 448 moves on to full education. All right, members, that brings us to our conclusion of our calendar. Before we adjourn, since this is our final calendar, let me just thank the folks that really make this all come together. I always start back with Elizabeth. So Elizabeth back there, yes, there we go, who records this for posterity. She's not even part of the AV team that makes it live stream and everything. She records this for the state library, I think. Isn't that correct, Elizabeth? So she records this, make sure that it's available to us. Thank you, Mr. Clerk, for all your work. Thank you. Yes, let's give the clerk a hand. Thank you, Sergeant at Arms. I think you've been our guy each time. Thank you to our legal, to Katie Robertson, yes, who definitely makes us all look good when it comes to our bills, that's for sure. And dots our I's and crosses our T's. Yes, there you go. And thank you for our research analysts, for Carly. Thank you very much. And then thank you to my assistant, who, when you end up becoming a chairman, then also your assistant has more work to do. And so thank you, Chelsea Rackley, for your work. All right. All right, members, with that, we are adjourned, subject to the call of the chair.